Thank you, folks. Have a seat. So this is the time for a hearing in 1 CACV 210061 in re DCS/Guardian. I want to begin with a comment. One member of the public did inquire yesterday and give us notice that that person intended to create a recording. That is what is required under Rule 123. That person certainly has permission to record. That person has also been told that in the recording, the person needs to stay in a seated position and not hold whatever recording device in such a way that it would obscure anyone else's vision or view and not be moving around the gallery. That was the only person who has permission to record. Now, these proceedings are being live broadcast across our YouTube webpage. They're also being recorded and will be posted on our webpage, and they can be viewed there later. So we are preserving a record of this, but I just wanted to make sure folks knew, and if they noticed somebody was recording, one person does have that permission. I don't know who it was, and we don't ask that. So I want to begin by putting this hearing into context. 14 months ago, in August of 2023, the department put the courts on notice of an issue with the Guardian system. Since then, the courts, the Attorney General's office, the department, and lawyers representing parents and children have struggled with the mounting delays. First, I do understand that these issues, and we understand, I should say, that these issues did not begin with the current administration. They began before. I do commend the current administration for stepping up and identifying the issue. I appreciate what the department has done and has done some things to move this process forward. I do also want to note that the department provided a recent update over our mandated appeals. It made sense, we could follow it, and we appreciate that. So what I'm saying is we do appreciate the department's effort, but from the court's perspective, the department has not done enough to fix this problem. And that problem remains at the department's feet. The time is to act, the time has come, and these hearings are going to focus on meeting the moment that is in front of us right now, not something that happened 3 years ago. A particular concern is the department's recent acknowledgement that it cannot, as of today, tell us which cases have disclosure issues. One point that the department made was case-specific issues of one document being overlooked. That is not the court's concern. The court's concern is not a mistake that may have happened on a case in one case. Those are addressed every day in court. Cases are dismissed, sanctions are issued, evidence is excluded, all sorts of things happen. The court's concern is the systemic issues. And the department has said the Guardian and, more recently, other systemic issues still prevent the department from ensuring proper and timely disclosure. From the court's perspective, the time has come to fix it. Now, early on, this court stayed and remanded a number of cases to the Superior Court to address the issue. Now, again, 14 months in, this court is staying every active appeal with the court, almost 100 cases, because the department cannot confirm it made accurate and complete disclosure in any one of those cases. The department recently advised the court that there are systemic barriers to full disclosure that are not limited to the Guardian portal. But the department did not say when it learned of those barriers, has not explained what those barriers are, what disclosure they affect, and what the department has done to alleviate those barriers. We will unpack that today. The department continues to operate, from the court's perspective, in a triage mode when an adjudication date approaches, only then addressing documents that have been backlogged on a case-by-case basis. The department has not otherwise addressed disclosure on this case-by-case basis. A few weeks ago, the department asked to meet with me about the administrative order underlying this case, an appropriate thing to do, especially with an administrative case like this. We met along with the chair of the Supreme Court's Committee on Juvenile Courts, that is Judge Anna Young from Yavapai County, and other staff and administrative officer members from the Administrative Office of the Court in Division 1 and also from the Attorney General's Office. At that meeting, the department mentioned wanting to convene a meeting with the agencies responsible for representing parents and children to discuss the ongoing disclosure challenges. The focus of that meeting would be on the department's process for disclosing documents over which there is no dispute the department must disclose them. The main issue is the format of the disclosure. For example, a list of documents or the documents themselves. The meeting is set in this building at 12:30 on October 17th, 2024. It will be broadcast for the folks who want to attend remotely. The various providers have been sent a notice, and I say providers, the various organizations and agencies representing families, not providers. So I should be very clear. I apologize for my little typo in my notes. To make sure that they are aware of that. They will be allowed to participate remotely. And we have sent a notice to all the presiding judges in Division 1, and some of their presiding judges may even choose to be present for that discussion. For who will preside over that, it is Chief Judge Starring from Division 2, Judge Anna Young, who chairs the Juvenile Court Commission, and myself. It is not an official court proceeding. It is not a meeting of any kind of committee or commission of this court. It is really to try and facilitate the resolution of these matters. And what we're going to do is keep it organized so that folks who may be listening who are planning to attend, that it will be in an organized fashion. It is not an opportunity to raise issues on specific cases. It's not an opportunity to litigate whether a particular type of document is subject to disclosure. If people disagree on that, that is something to be handled at the court in that case. What we're looking at is documents that everyone agrees need to be disclosed. They need to be disclosed timely, and how that is going to happen going forward and how the department is looking at accomplishing that. So it will be an organized, thoughtful discussion to reach agreements so that we can proceed. Again, the focus is on systemic disclosure and to iron out the issues timely, because we need to show respect for the families involved in this process. And it's been 14 months. Which is far too long for those families. I will tell you that in some of the cases that we have stayed, they have been pending for quite some time. They had gone to the Supreme Court and were remanded back to us, and we were prepared to issue a mandate, and we had to stop that. They were cases that had previously been stayed. We had been advised that the disclosure issues were resolved, and now we have stayed them again. So what we need to do over the next few months is fix it. That's the bottom line. There's no more. The runway is coming to an end. The plane has got to land, and we are looking to the department to make that happen. So what I want to do is at this point invite my fellow judges if they have anything they want to add before we proceed any further. Judge Howell?
No, at the moment, but I have other questions.
I'm certain. Judge Cruz, anything you would like to add?
Not by way of introduction. We're ready to get into the hearing.
Okay. As we get into the hearing, the Attorney General may not be able to answer some specific questions. I know that happens. What I am going to tell you is keep track of our questions, and we're going to tag them as we go along, because I'm going to be asking you to provide a supplemental report answering those questions as we note them throughout the hearing, and I'm going to set a deadline for noon Friday so that we get those answers very quickly. So keep track. I assume you have people taking notes. This will be available to watch, and so I'm not going to try and include them all in an order later. What I want to do first is invite the Attorney General then to the podium. If there's anything you'd like to add about the meeting a few weeks ago, again, I was giving it from my perspective. There may be something you want to add before we get into more of a discussion.
Good afternoon, and may it please the Court. I'm Kirsten Wright, Division Chief Counsel, Assistant Attorney General, representing the department today. With me is Deputy Director David Lujan. Also, General Counsel and Deputy General Counsel for the department are also present in the gallery.
All right. Okay. Anything about the meeting?
No, we wanted to thank you very much for having that meeting. I think it was very clarifying from our perspective as to what the court's expectations are, and we're hoping that we had answered the vast majority of the questions that you had in our response. Just by way of introduction, I do have some updates for the court with regard to the Guardian system, if I could begin with that.
Sure.
So phase one of making Guardian functional for us to use as a disclosure method was completed on September 16th. There is a phase 2 that will begin immediately, and we're hoping that phase 2 will be completed by January 1st of 2025. I know that this court has ordered that it become completely functional by December 31st. We are making every effort that we can to get the vast majority of disclosure able to be issued quickly and efficiently by that date.
So can you tell us what phase 1 is and phase 2?
Yes. So with regard to phase 1, new functionality was created. As I explained last time, portal documents come in from providers. So that would be substance abuse treatment, providers who are reviewing visitation, and those documents come in through the portal. Previously, they were stuck there, and a case manager had to go into the portal, review the document, pull it out, and put it into a case. The first phase with regard to Guardian was making those automatically approved. So now a portal document comes in through the Guardian portal, and it goes directly into the case that it's pertaining to.
And is this only for Maricopa County cases, or is it for all cases?
For all cases statewide. So the Guardian system works for the entire states. The disclosure part of actually sending the documents out is different per county, and we can go through those. With regard to that, yes.
When was that done?
That piece was completed many months ago. I want to say May of this year. That part of the regular approval, so it goes into the case, was created. So it's many months ago. However, the individual case manager still had to go in and pull out each of those documents to create a packet for disclosure. One of the new systems that has gone into place now and was functional is that as of July 1st of 2024, they can now just pick up and slide into a packet. It's a significantly easier process. Those documents are bundled together, and then the case manager can either send those to the CRCU unit in Maricopa County, or they can print their bundle or email their bundle to parties in the other outerlying counties.
I've always been confused in a normal criminal case, for example. The prosecutor is responsible for gathering and sending out the disclosure. Why is it the responsibility of a case manager in a DCS case rather than the DCS attorney at the AG's office?
So the department has the access to those documents. So with any client that you might have, your client has to provide you with the information to be able to disclose it. So the department, the Attorney General's office does not have access to the Guardian system. Only the department has that.
Why is that?
That is how the program was created, and I cannot answer that question for the previous administration who obtained the program. When Childs was around, our paralegals could go into Childs, which is the prior system, and pull documents out of Childs. Under the previous administration, that process was stopped. Our access to that was revoked, and I cannot answer as to why that occurred.
Why is the department not allowed access to this program? Because I assume some of these caseworkers are working remotely. It's not you must be in the office to access it. Why do your paralegals not have that yet?
Pretty much manpower, would be my answer. So at this point in time, the Attorney General's office has just under 100 attorneys and has significantly less paralegals to do that. The volume that comes in through the department is unbelievable. And the department has several thousand case managers who have the documents. The other issue is that the department's system does not track by JD number. So they don't track by case number, they track by person.
And you said that before, and I take that as truth, but given what's happened, shouldn't that change? So
that has changed. That is something that was implemented in phase 1 is now a case number has been added, but that's only for cases just in this last year, and as we all know, many dependency cases can last for a significant period of time. A case is still set up by person, but now the department is adding a JD number to each person. So we should be able to find the JD number, but it isn't a case exists and everything is added to that case. It's that a person exists and the documents are disclosed to that person or connected to that person.
And why is it set up that way? Has the department been advised that perhaps that's not the best way to do it?
I am not a coder, and I do not have a lot of technological knowledge of how the system was created. I do know that this system is used in other states and is considered a gold standard program for social work. And so again, I had said to you last time that this program was set up for social workers. It was not set up as a mechanism for disclosure.
Which is the problem.
That is the problem.
The department is trying to use it that way, and so is the Attorney General's office. Child's had the same problem, though. It didn't have it by case number.
Well, Child's had a mechanism by which you could hit essentially print all, and an entire case file would get printed. Guardian does not have that ability.
But they had to link them up to the case because, again, it didn't operate off of a case number system. It was always siloed. Am I misunderstanding that?
I don't know the functionality of Child's as well. I utilized it many years ago prior, when I was at the Attorney General's office prior, so I don't know the exact functionality of that, but I do know that it had the ability to gather a case together, print that case out so you would have everything that you needed in paper form.
So as I understand, and this is just for provider documents, so we're not going beyond that. Those are the ones that are going into this system. And as I read your report, those documents had to be coded correctly, if you will, from the provider.
Yes.
Or they weren't getting linked up to anything.
Yes.
So what about those ghost documents? I'm going to call them ghost documents because unless you tell me no, there isn't a single document that is not associated with a real case and a real person.
At this point in time, those can be found.
Not found. So
they
how
could
are
be,
they being found?
So they would be documents that don't end up getting associated with a case.
Right.
And let's say there are two very similar spellings of a name. The only thing that differentiates them is a date of birth, and the wrong one gets uploaded to the incorrect case. The case manager would have the responsibility of reviewing those documents in their case, making sure that it's correct, and if it's not correct, they can route it to the correct case. If there are documents that are sort of in the ether of the portal that aren't connected, the department can now see those. They can see that there are documents there and could pull them in and find the identifying information to make sure they go somewhere.
So what is the process for that? Are they doing that, and are those documents being connected to a real case?
I have not specifically asked that question of the department.
That's
yes.
One of your first ticks is these documents that are not associated with a case. What is the process to get them associated again? Once they're in your client's hands, that's the 10-day disclosure tick.
Correct.
So what is it they're doing to get those documents looked at and assigned? I'd also like to know the protocol for the folks who are the caseworker to double check the documents in that system promptly to make sure if there's a document that was assigned to the wrong case that they get rerouted. Okay. So those protocols are important to us to know that the disclosure in all the cases is happening timely and things are linked up correctly.
Okay. With regard to the finishing out the phase one, as of September 16th, the last wave of improvements were to sort of increase workflow, to make the workflow piece easier, and included additional disclosable materials, so items that can be pulled, clicked on and pulled over into a packet for disclosure. And that includes safety plans, family functioning assessments, both for investigative cases and ongoing cases where the dependency has been filed, custody notices, infant care plans, case plans, and transition plans. So transition plans from a child from one placement to another, and transition plans for a child to return home. So those plans now, all of those documents are very easily able to be clicked on, moved over, and have a disclosure packet created.
So is that just for the documents for cases from before 724, or is that all?
That would be for all cases.
Okay. The 724 has to do with the JV number now being associated with it. Is that correct?
Yes.
Okay. I'm just making sure that there's not a difference.
And then phase two will provide the department with the ability to easily disclose case notes. And just so the court understands the volume that we're talking about, last month there were 80,000 case notes created in just 1 month on cases statewide. That's a significant number. Prior to being able to connect these, what the department has to do now is essentially screenshot each page and print it. They do have the ability to put them into an Excel spreadsheet that we're hoping becomes functional and easy to use, and we can disclose that Excel spreadsheet with the case notes in it. But that's something the department is working to correct. So it is significantly difficult to capture those documents and get them pulled over into a packet, but that is something that should be functional by January 1st.
What about emails?
Emails. Emails are a very, again, there's something that would have to be screenshotted and printed, or a document has to be created. So you would have your screenshot of the email. You have to save it as a document, which becomes an artifact. That's the name for it in Guardian. It would then become an artifact. Then the artifact can be moved over. One thing with regard to emails that we have discussed is the other emails, obviously, with providers would absolutely have to be disclosed because nobody has access to those. But there aren't as many emails to providers as there will be emails between parent and case manager. The parent who's the recipient of that has received that email. So that piece of that disclosure has occurred because the parent has participated in that email. The other parent won't have received that, and we understand that that's an issue. But from the disclosure obligation, that is something that the recipient parent has received from the department. One way that we have talked about alleviating the need to disclose every single provider question or email between the parents is to have the department, when they send an email, copy parents' counsel on those emails between the parents especially, so that those are already disclosed, and that should help reduce the department's ability to do that. There are some concerns with that, making sure that certain information isn't disclosed to one parent that shouldn't be disclosed. We have many cases where there's domestic violence, and the cases are sort of bifurcated, and we have to be very careful that placement information, home addresses aren't provided to a parent that could endanger the other parent. So those are all issues that have to be worked through. The redaction has to be completed.
An email that you're sending to the parent and then copying counsel, presumably if you're sending it to the parent, you're not including that information in it. So I'm not.
Well, if let's say, for sake of ease, if you're emailing the one parent who's the victim parent, right, you wouldn't want any information. Perhaps that parent sends an email that says, I've just changed my address. This is where I'm living. Here's a copy of my lease, because that's something the department frequently asks for. You wouldn't want the other parent to have access to that immediately. You would want to redact that.
You're not necessarily copying the other parent. So I'm not sure, because counsel knows how to not do that. You know how, you as an attorney representing a parent knew how to not hand that to the other side.
Yes, I did.
And to the parent who might have been the aggressor. And
I think the concern would be that there may not be some diligent parent, and the department would hate for anything to happen to a victim parent because they did not redact.
Then I'm just struggling because the department still has the obligation to disclose. So if
Yes.
the department is going to say that is the concern, what is the department doing to fix it now? Because those emails need to happen. They
Agreed.
need to be disclosed. The provider emails, the provider letters, all of that.
Yes, so we are working on that system of how do we redact them all? Do we have them start forwarding? So that's something that is being discussed.
Timeline.
It is timeline.
Because it's been 14 months. So
I understand
from my perspective, that discussion should have been done. I mean, actually, I will go back to the first letter and the second letter, and we were supposed to be done yesterday, a year ago, by the end of September, and now we're here.
And
So what is the timeline?
I would let the court know. I can't give you an exact timeline. I know that we are trying to meet your deadline of December 31st. That is everyone's goal, is to try to have this certainly sorted out by then so that we have a well-oiled machine. It is an extremely large organization, and you have a lot of turnover. And so turnover in archiving emails has become a technological issue. So when someone leaves, all of their emails get archived. A new case manager comes on, and she or he would have to look and make sure that those previous emails had been disclosed. So that is something that, with the technology piece of it, is making sure that there's someone that can access those archived emails and ensure that they have been sent out in a packet.
So who has access to the emails when a case manager leaves?
I am not certain of that answer.
We probably will answer. We'll have
Yes,
you
we
answer
will.
that.
We will answer that question.
All right. We do need to know who has access, and it seems as though new specialists aren't do not have access to those. So it's important to find out the answer. What is the department's email retention policy?
They would follow the retention policy. There's a policy for the department with regard to the age of the child and how long they have to hold on to that. It's a significant period of time. I think it's past it. I please do not quote me, but it's at least until the child has turned 18 and a period after.
Has the department set up a process? So that retention policy then dictates how long the emails are preserved and disclosed if necessary?
How long they are preserved. I don't think disclosure is a piece of that retention policy.
So
Go ahead.
what about case notes?
So case notes, that is our next part of phase 2. That's the first part of phase 2. Right now, the case manager is responsible for taking those case notes and either screenshotting them or putting them into this kind of Excel spreadsheet and making sure that those get disclosed. In order to make sure we're supporting them, because that's not something that the department has traditionally routinely provided, our assistant attorney generals, are making sure in every communication that we have with them, please make sure you're disclosing your case notes. So we are trying to remind the case managers that that's their obligation and trying to work as a team. And as I said, I believe when we met, we from the Attorney General's office are trying to start from the bottom, from the line case manager and our line attorneys, and providing information and requesting information from them every day so that we're helping change that culture. And the department is working from their management system down. And they are making sure that their PMs and their PAs and everybody understands what the process is and what needs to be disclosed, so that hopefully when we meet in the middle, we have a culture change and a technology change that will allow the department to ensure that all disclosure is being made in a timely manner.
And if we're understanding it correctly, if I may, the Attorney General's office is doing a last-minute disclosure check with case specialists and with the CRCU. Is that correct?
We are speaking with the case specialist. The case specialist knows what has been sent to CRCU, or they should know what has been sent to CRCU. So the case specialist is making sure that it has actually gone out. So the case specialist gathers that packet, sends it on to CRCU. CRCU then reviews redacts, and then they disclose in Maricopa County, they disclose to JAX.
Okay, and how is that going to be a permanent process within?
Yes, that's the department's intention for that to be a permanent process.
So the reductions occur in the CRC only in Maricopa County.
Correct.
How are the reductions occurring in other counties?
In other counties, either a case aide or the case manager will gather those documents, review and redact, and then they're put in packets and emailed with a cover sheet, and the cover sheet has on it exactly what's being disclosed. I believe Mojave County requires that the disclosure is filed with the court, so if it's in a county that needs that extra requirement, then they're following up with that.
And I assume there's a faster process than going to the CRCU?
The number of cases in the outerline counties is significantly smaller, so we are talking on a just dramatically reduced scale. For example, I believe not all 8 counties that are under Division 1 have pending appeals. There are some counties that don't have any pending appeals cases just because the volume at this point in time is smaller in those cases, in those counties. So the case managers have the ability to review their cases in a more timely manner.
And I understand that your client and you want to have a systemic resolution of these issues, but given that we have specific difficulties with current cases, why couldn't you do as they do in the out counties just to resolve the current immediate crisis with the cases that we're dealing with? At least appear there are around 100 cases. And again, I realize you want a systemic way to process these cases, but when you have a crisis regarding a subgroup of cases, can't you do that with that subgroup?
Meaning have the other counties process Maricopa County's disclosure?
The way that it is done in the other counties.
So
for the subgroup of cases that we're concerned with, can't DCS and ENP resolve the disclosure in a similar way? Just to resolve the current
the current Court of Appeals cases.
Yeah.
So we actually have, it's our position that the system that we have determined for this is going to move things along more quickly. The department has identified specific people who will review these cases at CRCU in Maricopa County. We also have identified specific people in both, there's someone in Globe and someone in Yuma, and someone who will do the rest of the Northwest cases. So we have an identified specific person who will be reviewing that. So they'll be pulled off of their specific caseload issues and processing those. We have assigned it to one attorney general in our office to go through each one of those cases. The volume of casework in juvenile matters is astonishing. Our attorneys are in court every single morning, and they are frequently in trial in the afternoon. So to have those case managers that are appearing in court and doing their casework, which entails meeting with families, making sure that they're putting in referrals, seeing children, to ask each individual one of those to add to their plate, we think would slow the process down. So we've identified specific case managers and a specific assistant attorney general that will go through these 100 cases, hopefully very quickly, to get them moving again and get them back to you.
What is the timing of that? What is very quickly?
We are hoping to meet the 30-day deadline that the court has put in place. The issue is with the amount of time it takes to review each case. So we have the disclosure that's been provided by the department. We also have documents that have been subpoenaed by the Attorney General's office, and so we have to make sure that those match. We have to look at the entirety of the case to ensure that either DCS or the Attorney General's office has disclosed those documents and there isn't anything that's missing. Going through those takes a significant amount of time. When you have visitation records, there can be hundreds and hundreds of visitation records, and you need to make sure that every single one of those is there. So one of the things, yes.
Well, go ahead and finish that thought.
So one of the things that we've noticed is with regard to the portal documents, the original portal documents that didn't get disclosed, the vast majority of those were parent visitation records. But it may have just been 1 week that hadn't been disclosed. So it wasn't the entirety of the parents' visitation records, it was just one document. So in order to assure and sign an avowal and have the case manager sign an affidavit, we have to ensure that every single one of those visitation records is in the record and was provided to the parents and the Children's Council.
So taking it back to sort of a broader question, the department has reported systemic barriers to full disclosure that are not limited to Guardian Portal. What are those systemic barriers?
I think some of it is culture related, that previously some internally created documents were just not disclosed from a practice.
Can you tell me what those were?
I can't give you an exhaustive list, but I think case notes probably fall within that. There are some education records that might not have been disclosed. I think it would depend upon the specific unit and the specific case manager as to whether or not certain documents were disclosed.
You would identify that for us in the supplement.
Okay. I will say
I'm
that
helping somebody behind me.
having said
I would
that,
rely on someone else.
yes,
to do that.
I am. Having said that, because the document might not have been produced, that doesn't mean that the information wasn't produced.
It's not the same thing.
It is not. I agree that it's not the same thing. So I'll use a referral, for example. So in any court report, there's a section that says what referrals have been made for this family. The identical information that's on the single sheet referral is in the court report. So I don't want this court to think that there was all of this information that was withheld. It was provided, but the document may not have been provided, and that's mincing words.
That's not complying with the disclosure obligation. The document
Agreed.
is what does have to be provided. And so I struggle with the email for the same reason. ESI is not new. It's been around for a long time, and the department has an obligation. And you've got emails, and the department has to have a system to make sure emails related to the case are disclosed. And you can't just say, we archived it. I will tell you, I sat in courtrooms as a judge watching people try and do that. It doesn't work. The process, just because the department adopted a process of archiving them, doesn't mean the department doesn't have to disclose them. So what I'm looking for is, what is the department doing now to open those old email accounts, go through them, and make sure they are linked to open cases, and in particular open appeals, and get them linked up now, not tomorrow, not next week, because it's been 14 months. So it's not new to the department. So now, I don't have patience for, oh, but that's going to take some extra effort. It needs to get done, and I know you can walk and chew at the gum at the same time. I personally have problems with that. I find it challenging, but I know you can. So I just want to be clear on some of these things. Culture is not an excuse for not disclosing at this point.
We understand that.
And it sounded like you began a list of some of the systemic barriers. So first, culture?
I would say first is culture, and so we are working to change that. This administration, both from my end and from Deputy Director Lujan, it's our first priority is to ensure that. There are a lot of new case managers, so I'm hopeful that this becomes their routine, and that's how they proceed. I would like to say, however, that technology does take some time. And it takes money. And the department is working very hard with the governor's office at this point in time to ensure that both of those things proceed in a manner that is expeditious and that this court can.
Well,
yes.
Counsel, but you're also using outside sources. And I
Yes.
believe the contract that you provided us relates to the contract for cases that have been mandated and cases, closed cases, and getting the disclosure out.
Yes.
Is the department going to use that process to get current on any delayed disclosure at this point? Because technology isn't the only answer here.
So just the department has done that. So there were 8,449 sort of backlogged documents that were with the CRCU. Of those, all of them have been redacted, and there are 3,600 that are left to be uploaded into JAX. So the 2/3 of them have been uploaded into JAX at this point in time. And when I checked those numbers, that was last week, so I'm certain that they're further ahead than that. All of the letters and documents to the parents were sent out and completed by September 20th, so any of those portal documents should have all been disclosed now.
So I, again, want to focus on open cases. Are we talking about open cases?
Yes. The 8,000 documents were the backlog in open cases.
So when we were last here, the department acknowledged being 4 to 5 months behind in disclosure. Are you telling me today that all of that backlog is cleared? Or the numbers you were just giving me is clearing that backlog?
Those numbers are clearing the backlog. But there are still 3,600 or less than that at this point in time to upload to JAX. So they've been redacted, they've been processed, we know they're associated with the correct case, and they're being uploaded into the court disclosure system, into JAX, and those are on open cases.
Okay. Including open appeals, which I assume are still
yes.
open down there because...
If there were documents on open appeals, those would be being uploaded, yes, and disclosed.
Now, as far as 100 cases that are before us that we're immediately concerned about, the answer I heard from you is you're working hard and devoting resources to resolving those matters, but you can't interfere with the ongoing caseload. And it seems odd to me that you've got newer cases who are being treated the same as cases that have been around for a long time, so long that they are up here on appeal. I understand your desire to keep things moving and not gum up the works, but because these cases are so old compared to your newer cases, does that warrant treating them separately and differently than just the case that is in the hopper being processed?
So my response to that would be that we're treating them differently to try to expedite them. That would be the difference, is that I think we're taking those cases that are on appeal. We understand that some of these, as you said earlier, Your Honor, that you have a case that was coming back down from the Supreme Court, you were getting ready to mandate it, and now it's part of this process and has been stayed again. We don't want that to happen. So we are trying to put the resources towards those cases to ensure that they are processed as quickly as possible, because they are older cases and we want them to be resolved.
When you say quickly as possible, the limit on that, at least like I heard you say, was, we can't pull people away from the ongoing cases to resolve that, because the ongoing cases have to be dealt with.
So part of that issue is a quality assurance issue. So as I said, going through these documents to ensure that we didn't miss 1 week of visitation notes, and to ensure that all of the educational records have been provided, and if a child had a best interest determination meeting 5 times, that all 5 of those documents get disclosed, it's extraordinarily tedious. You have to look, you have to open up JACs, you have to open up what we subpoenaed, ensure that those are the same documents, ensure that the list that comes from CRCU shows, hey, this is the totality of what's in this case, has any of it been disclosed? It takes between, I believe I said, a case that had a couple of documents that we were reviewing for the first set of cases, anywhere between 15 minutes per case to over an hour if the case has several documents. So we're trying to make sure that the department says they've disclosed everything, then our office is re-reviewing that to ensure that we think that they've also disclosed everything, and it's an extremely time-consuming process, and it is ripe for human error. So if we have line attorneys working with case managers who have 100 other things going on, and emails are coming in and the phone's ringing and they have to appear in court, we're worried that there's going to be error and what we provide you isn't accurate. So we have assembled a team to go through that in the most expeditious way possible, and also to ensure that the quality of what you're receiving is as close to perfect as we can provide you.
But if you need to call away a case manager to provide you information and call him or her away from testifying in a current matter, you're not going to do that.
Well, if another court has ordered that they be present, I would hate to have them delay a trial on another case due to, we have the resources set aside to move this through as quickly as we can. The department has committed a specific number of case managers to review those documents. CRCU has set aside a specific number of people to do that in Maricopa County, and our office has, our section chief is doing that. We have a high-level attorney looking at every one of these cases to try to ensure that we do not make mistakes, that we provide you with everything that you need, and that we're signing an avowal that we feel very comfortable with.
So by what date will all those cases be resolved as far as disclosure goes?
That is our goal, yes.
Yeah, but when?
So we have the dates for the stays, and then I think the court has provided within 30 days there has to be some sort of resolution. I have spoken with the Maricopa County presiding judge, because that's the vast majority of these cases with regard to processing and how that the court would like for us to do that. So we have a list of all the Maricopa County cases. We're going to provide that to the clerk so that we can get hearings set. If we need hearings very quickly, the clerk's office will be aware of that. There is a lot of behind-the-scenes action that's going on to ensure that we can move these through as quickly as we can, and that the court feels comfortable with it, and our office and the department is providing everything that's needed.
So, counsel, because of doing that, I'm just going to come back to 2 things that you've identified, and I don't know what else there may be, but case notes then need to be all screenshot and put into that document with that case. Emails need to be looked into, including former caseworkers, and the department knows which caseworkers worked on which cases when. That is a history that is there. So that's part of what we're talking about. Is that all stuff that you're getting done right now?
Yes.
So you expect to be able to accomplish that?
Well, our goal, yes, we've informed the department case notes and emails need to be disclosed. So that is part of that review of the Court of Appeals cases, is that the department avows to us, we have that conversation, this all has gone out, either uploaded to Jax or emailed out to parties, and then we can make our avowal that it's been disclosed.
And we understand that as new appeals come, that same requirement applies. So I don't know why we would, I mean, it seems to me you do have to fly the plane and build it at the same time.
Yes.
Those cases need that same disclosure. A case with an adjudication tomorrow should have already had the emails and the case notes disclosed. But it doesn't sound like that's happening.
It is happening now. I mean, that's what I mentioned earlier, is that our assistant attorney generals are having conversations with the case managers to ensure that things are provided pre-adjudication. Our goal is to have the case managers willing to sign the affidavit prior to the adjudication, so that that's done. And we're not having to go, we're trying to start upstream.
They're getting access to the closed email accounts too, to make sure that the former caseworkers are also getting disclosed, because that is part of this. How did this start? What was happening early on? And some of these caseworkers take over 3 weeks before a trial. So really, it's the former caseworkers' emails that matter. So is that getting done?
As of today, no. That is the one area that we still need to resolve.
So we're not able to move our appeals forward until that does happen.
And that is what our team will be working on, is ensuring that those documents are going out prior to coming back before Your Honors.
Case notes are in the same situation. Do case notes stay with the case or with the caseworker?
With the case.
And so they can download every case
Yes.
in the case. Okay.
So what is the timeline for expanding Guardian reporting capabilities beyond provider documents?
So by January 1st of 2025. So it's, as of right now, it is all of the provider documents, safety plans, family functioning assessments, custody notices, infant care plans, case plans, and transition plans. All of those have the functionality. The big ticket item is case notes, and so that case notes will be provided. And one of the reasons we asked for the convening with the defense bar is, for example, I'll use referrals. That seems to be my favorite example to use, but there is a report that is run that has literally a list of every single referral that's been made in the case, the date the referral was made, the date that it was picked up by a provider, what provider that is, and whether or not the contract piece of it, the referral has been completed or is still open or was canceled for some reason. So we have the ability to produce that document, which has all of the information on it and is probably significantly easier than producing the 35 individual pages. So our goal is to see if that's something that the defense bar would be willing to have initially disclosed. And if they say, hey, this September 3rd referral, I'd like to see that page, we'll produce it immediately. It would save the case managers a significant amount of time. It would save CRCU a significant amount of time in redaction to be able to do that.
Why CRCU would have to ever review referral letters?
If the referral has placement information on it, that would need to be redacted. Sometimes referrals will have Social Security numbers. That's something frequent that Teros used to require. I don't believe that they require it anymore, but some providers require Social Security numbers. They require, so the referral would have all of that information on it, and that needs to be redacted, the referral page itself.
This is a very basic question, and I apologize for my ignorance. Why does all this information need to be redacted? I mean, isn't some of this information common knowledge to the other party?
Some of it would be, but I don't think anyone would want their Social Security number provided to all of the parties in the case. So like your Social Security number has to be redacted. Placement doesn't want their information provided to the parents. So placement's information needs to be redacted. I mean, there is information. If you have a case, again, like I said, in a domestic violence situation, the victim parent would want wherever they're living, they would want that address redacted so that the other party doesn't have access to it. So there's a practical piece to it.
The volume of information that needs to be redacted is too much for the assistant AG to do?
We do not have the capability to do that. We redact there are certain items, I listed them in my response, that are sent directly to the Attorney General's office. So psychological evaluations are sent to our office for redaction. DPS records are sent to our office. There's a list provided in the response that are sent directly to the Attorney General's office, and we do the redaction and disclosure of those documents.
At the beginning of your response, you said that there were disclosure issues after all cases. I was concerned by that.
I said there's potential disclosure cases. If like I said, if the one visitation note doesn't go out that could have been missed, I would consider that a disclosure issue because the parent's entitled to that document. And so there might be one page of visitation records that doesn't go out, or there might be, if we receive urinalysis testing from PSI, you always want the confirmation test. So maybe the list of whether the person tested positive or negative gets sent out, but there might be the missing confirmation test. That confirmation test might become important at some point in time, so it should be disclosed. So I can't avow to this court that in every single case there has never been a page or two of missing documentation just due to human error. So when I say that it's possible that all of the cases may have had a piece, it's more on that level, that one or two missing pages, maybe the referral page didn't go out, but the referrals were documented in the court report, so there was notice of what those referrals were and what dates they went in, but the actual referral pages didn't get disclosed. They need to be, but they didn't.
So those instances you're talking about are idiosyncratic issues pertaining to particular cases. They're not systemic issues.
I think with regard to emails and possibly case notes, then they would be systemic issues.
I'm going to agree with you there. And the problem is it's been a systemic issue that the AG and the department has been well aware of for 14 months. So I don't see that there's been an active effort to get that resolved. So it needs to become a priority. Are there other documents besides case notes and emails that fall into that systemic category? Because I want to know the universe.
So we have asked the department to provide a list of the universe of documents. So apparently in Guardian there are just over 1,000 data points. And so those data points can be a million different things. There are approximately 500 what I would call documentary pieces. So there's approximately 500. Of those, some might be things that would never be disclosed, such as placements, bank information, because the department makes the payments to the foster parent, and so their bank information is included. That would never get disclosed. It's not relevant. It doesn't have anything to do with the specifics of the case. So of those 500, that might shrink down because there will be those types of things. They're billing information. So Teros's billing that they send on a case, that would get attached to the case because it's attached by person, but that would never be disclosed because that's the contract between Teros and the department and what their billing information is. So there are documents in the system that wouldn't fit into that universe of something that would be disclosed. So we think it's 500 or less data points that could be disclosed through Guardian.
So we're 14 months in and we're still thinking there might be. When are we going to know what data points need to be disclosed? And October 17th, we're having a convening to talk about those specific data points.
By October 17th, we will have that exact list. The attorney
What do is say it needs to be earlier than
earlier,
that,
yes.
The defense counsel that are going to be appearing need to see that list. So what deadline?
By October 10th, we will have that to you.
So by October 10th, we'll have a list of the data points we're talking about. Now, again, we're still not into, and I want to go back to Judge Cruz's question, we're still not into everything, but what other non-Guardian documents are there, any that you're aware of? Because we just talked about Guardian data points. Emails are not Guardian data points.
So any document that is created by the department would be saved into Guardian.
Except emails. Except
for emails. I cannot think of anything besides emails.
Let's make
The case man, I will definitely double check that. I'm sorry, I didn't mean to interrupt you. So besides, I think emails are the only thing that are not able to be
How about
saved
text
in Guardian.
messages?
Text messages, yes.
My experience having sat on that bench is there's a lot of that happening.
There are a lot of text messages, and again, the parent who's sending and receiving would have those text messages. It would be the other parent who might not have received those. So we do need to establish a plan. The department has inquired with regard to programs that will save. Otherwise, the case manager would have to screenshot everyone, email it, make sure that it gets emailed correctly, and then that email gets uploaded to Guardian for disclosure. So there are programs that can gather those text messages together. I believe at the beginning of last year, the department looked at that, and it was cost prohibitive at that point in time.
Disclosure doesn't have a cost prohibitive. Discovery might, but disclosure is not a cost prohibitive concept.
That there is the caveat in the least burdensome manner possible, and so.
But if you don't disclose them at all,
Yes.
that's the problem.
Yes. So the department is looking for a solution to that situation.
So I expect at the 17th we'll hear what that proposed solution is.
Okay.
And I'm saying this because it's been 14 months.
I understand.
The time has come to not be thinking about it, but to be doing. And so that's why I need that. And I think defense counsel need that, because it's these families that we're looking at, these children, these parents.
And I want to assure this court that this is not something that has ever fallen by the wayside in the last 14 months. It has been at the top of our priority list. It is discussed every single solitary day between the Attorney General's office and the department. We have come up with solutions that we thought would be fantastic, and when we try to put them in practice, it doesn't work. So it is something that has evolved and changed. Someone said that it feels like we're digging into quicksand. As soon as we get the hole open, something else comes over and covers it up. So I just want to assure the court and the defense bar and families that this isn't something that the department has sat on. They have been actively working for a solution to this. It is a much more complicated issue than we had any idea when this issue was discovered. We had no idea how deep the issue was.
And I will come back to, I commend you in the department for doing and stepping up now. It's just, we do have to get it moving forward. We have to get to the bottom of the quicksand. These families deserve that. And I know you understand it. You've represented them. So
Absolutely.
I take you at your word that, and I can believe that it has been the subject of discussion. It's just, it needs to move now. And that's where we're at, because I can't move forward with appeals that we're ready to have decisions issued the day before that had been stayed before. In fact, one of our cases that has been stayed went back, had the disclosure litigated, came back up, we litigated the disclosure issue, and now we're staying it again because of another potential disclosure. So while I do respect what you're working on, and I know it's hard, we got to do it now. Tell me exactly what you're doing with our current cases. I'm going to foreshadow what I'm looking at.
Okay.
Because from my perspective, emails need to be done, case notes need to be done, and the other documents need to be done in these open appeals. Documents from providers, police reports from DPS or whoever, anything that was subject to disclosure, text messages, needs to be done. It needs to be done quickly. And we have been talking with Judge Howell a little bit about the old-fashioned way. You subpoena the records. I heard you say subpoena the records. What is the department doing to make sure that the current provider documents that you're looking at in these open appeals and in your cases are complete and that the disclosure is done? And what I'm looking at is potentially ordering the department to subpoena those records. And if you're telling me you're already doing that in each of these cases, that's fine. But I want to know.
So there will always be a lag. Say a case goes to trial on August 30th, no one will have received the documents for the month of August because they haven't been created by the provider yet. So there's always going to be a lag with regard to documentation. And so some of what ends up, I think that we're looking at with the court, the court asked for us to ensure that all disclosure was made prior to the adjudication date. We have expanded that ourselves, and we are looking at the order, the date of the order, to ensure that any of those documents that may have happened within that month prior to are also getting sent out and disclosed, so that anything that comes up to you, the full record should be there. The parties should have received them. So we have pushed the date out a little more to the order that the Superior Court is issuing that is on appeal. With regard to ensuring that process runs smoothly, that is as I said, we have assigned specific people to ensure that all of that is being looked at. The provider's documents come in monthly, usually. So each month as they come in, the department should be sending those out. When we go to trial, our office is subpoenaing only the provider records that we need. For example, if mom has had a psychological evaluation and we are proceeding to trial on father, we aren't going to subpoena mom's psychological evaluation. We'll only be subpoenaing the documents with regard to father's case. So from that instance, not everything is going to be subpoenaed. Mother might enter a no contest, and so we don't have to subpoena those documents for her case because it's settled prior to adjudication. So it's kind of difficult to say that our office is subpoenaing all records. We're only subpoenaing the records for the parent that is going to trial.
So, and I would say the same on appeal. Nobody's asking folks to deal with somebody who did not appeal. At this point, we're looking at our open appeals. But when I'm looking at, for example, a father who has appealed, that the records for that father and that party were actually subpoenaed. The records for the child were actually subpoenaed. And that occurred timely. And do we need to order it here to make sure that the department actually had, are the records the department, by not issuing a subpoena, didn't have?
I don't know that I would ever ask this court to enter orders against my client. However, with regard to proceeding to an adjudication, our office is subpoenaing the records that we believe we need to prosecute our case. So
but you don't know if you completed the disclosure. In other words, I'm struggling with that because the department is the one who, the two lines. The department sometimes makes people self-refer and go to their own provider. And for a service, the department is required to provide.
Yes.
And the department sometimes has the person provide it. It seems to me under either of those scenarios, those are the department's records to disclose, not use at trial. So what I'm hearing is the department isn't making sure it has disclosed those. It's just making sure that it's got the records it wants to use.
The department should be disclosing all of those documents, but with regard to subpoenas only. So when you were asking about subpoenas, we will only subpoena what the AG's office will only subpoena what the AG's office believes we need to use at trial. So there might be documents out there the department has disclosed. It could be, let's say father has gone to a parenting class or has done other community-based services all on his own. If the department's received those records, then the department will have disclosed those. But we don't necessarily need to subpoena those records to proceed on our case, right? We wouldn't necessarily need those records from our point of view.
But the father might want them to defend against that, and it's the department's disclosure duty for the services the department has either provided or required the parent to do.
Absolutely.
So how do you get around that subpoena obligation to meet your disclosure obligations?
Because as the department receives them through the portal, they should be disclosed.
And if the department hasn't received them? Does the department subpoena the records when it hasn't received them?
I think that would be a case-by-case basis, depending upon, I think most of the time we would subpoena them.
The department either decides it's going to issue subpoenas for those records or it's not.
Correct. I believe if we had not received I think it would be on a case-by-case basis as to whether or not the Attorney General's office would subpoena records. I think we'd have to know what the records were. If they don't have the records, I would certainly hope that the case manager will be reaching out and saying, hey, we don't have the last 2 months worth of records. We're going to trial. We need those. Communicate with the Assistant Attorney General and say, hey, they're ignoring me. We need to proceed and have a subpoena issued. That communication piece should be occurring.
And that's on all documents?
Yes.
Because from my perspective, just because it's the AG who wants them, that doesn't mean the AG doesn't have that disclosure obligation.
No, I agree with that. But when you said if the documents haven't been received by the department, there should be a communication between the case manager and the assistant attorney general for us to know that the department hasn't.
To make sure that happens?
There is not a protocol, but it's a practice, so we can put a protocol in place.
I'm not trying to tell you, I'm just
Absolutely.
wondering how it happens if it's not, and you're talking about culture. And practice usually comes off of culture, not protocol.
Putting aside the idiosyncratic issues that can happen in any case, are there systemic disclosure problems going forward? You say that you're generally current as of September 1st, 24. I was kind of confused about what you meant by that. And my larger question is, going forward, have we solved the systemic problem?
When I stated that we're moving forward, I was referring specifically to CRCU. So that disclosure group that went out, those 8,000 documents that we had another company redact, that has helped get CRCU back on track so we don't have that 4 to 5 month delay. So that's what I was referring to. As far as systemic issues, I think sometimes culture is hard to change, and so we're working on it diligently. We've made dramatic improvements. Case notes are being sent out. Educational records are being sent out. So I do believe that the system is changing, that we are working towards that change in culture, that the department understands what their obligations are. It's been told to them what their obligations are. I also don't want...
So you are or are not accruing additional disclosure issues going forward with cases?
I'm not certain I understand the question.
I guess going forward, have you solved your problem systemically going forward with cases? I know there's a backlog in back cases, but going forward, have you solved, and I put it in air quotes, have you solved the systemic problem going forward?
I don't think we have completely solved the systemic problem going forward because we're still working with emails and text messages, and that's something that has not been quote unquote solved in order to be able to move forward and say that systemically there aren't any issues.
So those problems will show up here. They will continue to show up in the future here before us.
My hope would be that it would not be any longer and that we certainly would have that figured out by that December 31st deadline, that there is a workaround in the system that allows Guardian to produce things, allows the department to be able to, you can create a document in Guardian, so perhaps there needs to be some sort of communication piece with regard to the two systems of saving emails in Guardian, and then those can be dragged over and put into the packet that gets sent to CRCU or put into the packet that gets disclosed. So those are things that we'll have to work out from a technological standpoint. In the meantime, there is a mechanism for screenshotting and printing every email and getting those sent out.
You mentioned dead records. Are they part of the email case notes problem, or they go in Guardian? Where do you?
I'm sorry, I missed the first word you said. I admit.
Education records.
Education
Where do they go? Are they part of
email? They're part of Guardian. So education records, so there's a best interest determination meeting. There's a form for that. That form can be disclosed. If there is an IEP that comes in from a school, that would be saved and uploaded into Guardian, those types of educational records.
How does it get saved and uploaded?
So you can save it, you create it into a document and save it into Guardian. And
so is there a protocol saying caseworkers make sure these things are put in there?
Yes, the department is to any document that they receive, if it's does not come in through the portal, they would scan that in and they would save it as an artifact.
So I'm going to go back to where this started.
Okay.
And that's caseworkers just didn't do it. There are 100,000 some documents sitting there that the caseworkers were supposed to and didn't. Is there a protocol to make sure that it's actually happening so we don't sit here in December and go, there are a lot that didn't. We had this problem where somebody put a lot of appeals in a drawer from the unemployment benefits. And I worry about that right now because we're here because of that.
So
what's the protocol? What's the plan?
So the department
caseworkers are doing it.
The department is working with their management team. It's something that's discussed at their management meetings. As I said, from our side, the Attorney General's office is reminding, and we've developed, I believe I provided it to you at the meeting a couple of Fridays ago, a checklist of, hey, make sure when you're disclosing and we're getting close to trial, or if you want to staff a case for a case plan change, look at this list of documents and make sure that anything in the case on this document list has been disclosed, or any additional, this is not an exclusive list, but make sure that you're getting everything sent out. So we're working from a supervisory part on the department, and then from the Assistant Attorney General side on the Attorney General's office.
I heard a key set of words there, and I just want to be clear. I get it, that as you're getting ready for trial, there is always the last minute going through making sure everything happened. But in every case, every week, every day, there is a disclosure duty that is triggered. It's not just when we get there. So what is the department doing to make sure the caseworkers are actually getting that done on a timely basis, not waiting until, maybe we'll change the case plan, we have a permanency planning meeting, we got to do this.
So I think from a supervisory standpoint, that's where that sort of checks and balances is coming from the department.
Okay. There was something, go ahead, did you have something? Did you have anything further? No. Can you just slide back here a second? Give me 1 second.
Certainly.
In council, I had mentioned, and I figured you didn't need us to walk off the bench to come back on the bench. I was very seriously looking at requiring the department to do the subpoena in the open appeals to make sure that it got done and that there was no delay. What I'm going to do for right now is wait and see what your October 24th report says. I think you have another one due come October 30th to see what's happening. And so I encourage you to get it done, and that way I don't have to think anymore about doing that subpoena order. And so I want you to focus on that. The second thing I did think of the question, which is you identified that the disclosure would happen by October 1st in things. Is that the disclosure you were talking about? Because you indicated in one of yours that the third party or person doing the disclosure and the redaction for you would complete it. Is that what you were talking about, that we still have about 3,000 documents sitting in?
Correct.
In limbo? You had identified longer documents, 100,000 pages. Are they also included in that disclosure that's been done now?
Yes.
Okay. I just want to make sure that
let me retract that. I believe that very large document is currently with CRCU, and they are redacting that one large document.
Okay. And if CRCU hits a backlog, that law firm is there to pick up and say, okay, we're going to handle these, so that we don't have the CRCU blockade, which seems to have happened at some point, where they had a backlog that wasn't getting done.
I have not specifically asked my client that question, but I do believe that is something that they would be more than willing to do, should a backlog occur.
If CRCU gets backed up, then we're just back in the same place we are.
Absolutely.
And then it doesn't work. So there needs to be a backup plan for how CRCU is going to be covered if they get caught. All right. What I think we're going to do, and I don't want to belabor things too much today, we're looking at having the October 17th hearing. Again, that is open to the public. It can be viewed remotely. Participants are limited to participant agencies who represent families or their representative in the AG's office. So it's not a public meeting. We're not going to be taking public comment. It's not a committee meeting. It's a convening to try and work through some of these issues, but it will be broadcast so people can watch it. It will be put out there on the internet on our webpage for those who want to. That'll be October 17th. It's going to be in room 119. and that is in this building, and it will start at 12:30. The second thing that I want to do is our next hearing here is going to be October 29th. That'll be at 1:30. It will be in courtroom 2 again. And you folks can expect that we'll be coming back every 2 weeks until this gets resolved, because I have 100 cases, and I'm only a little piece of this. But every one of those appeals that comes up here represents somewhere in the neighborhood of 40 cases that didn't get up here. And so from my perspective, while I'm not managing them at all, for me to make sure the 100 cases that land here happen right, those all 4,000 down below have to happen that way. So that is something that we will be doing on a regular basis. So we'll see you back here on October 29th.
Your Honor, may I ask one clarifying question? You
Yeah.
wanted the answers to these questions by this Friday, is that correct?
Correct.
Okay.
We put a pin in some of them. And if I didn't expressly say it, but you think, hey, you probably wanted that one answered, I apologize. But
Okay.
might not be a bad idea to provide an answer.
Okay. And thank you again for your
That'll be
time.
in JB 61.
Okay. Thank you very much.
Thank you, folks.